Okay.
That's a compliment.
I will call the meeting of the Board of Adjustment to order. I'm Frank Benish. I'm the chairman of the board, and we'll introduce others as time comes. We have an agenda of 4 items today. What was published in the newspaper had the selectmen's motion on Rupel first, but I thought since there's, I believe, an attorney present who obviously charges, we might hear the Evans notice first. But I'm amenable to the board making any.
No problem, yeah.
Okay.
Here.
And who's present for Evans? Is that?
I'm Dave Evans.
Okay, hi, Dave.
And Ken Cargill represents.
Okay, Ken. So why don't we hear that, conduct that hearing first. So I will, you're welcome to come up here. I'm going to open the public hearing in this appeal of administrative decision. What a public hearing means is that the applicant has a chance to make a presentation. Abutters or other parties with a direct interest have ability to comment, and then the board will deliberate, and we may make a decision, we may defer it, but that's the drill. So we start off with your presentation, Ken.
Okay.
And we all can get started. Let me. Everybody on the board has seen your application. Okay. I'll state right at the beginning. When I first communicated with Mr. Evans by email, I had not seen the rejection letter, so I was uncertain exactly on what precise grounds the town denied the permit. So I did have some material in that email talking about frontage. I don't think that clearly now that's not an issue. The denial letter was entirely, I think, addressed on 674-41.
Right.
So I think, at least to save your time, we can probably focus on that.
That was my intention, right? And it's 2 responses to that. And I just thought, if people haven't seen the lot, I always like a little visual, so I was going to put a plan out here. The best plan that shows the lot is actually the septic design plan, and it's upside down. This is the lot. The locus right here, which is off of Black Mountain Road. It's about a 1.9 acre lot. And the lot itself is up here, and it has a driveway and a bridge crossing out to Black Mountain Road right there. And I apologize for this being fairly small. Now, the property's always been accessed this way. The bridge goes in there, and it had been used seasonally, and there are some improvements on the lot. Since the date of this drawing, the Evanses, the property owners, have obtained an easement deed so that they own this land. This little tiny strip of land here happens to be owned by the Davis family. And no one paid any attention to it because it was just a little hop across, but we said, all right, we'll clean that up. We've got an easement deed, so now the property connects directly to Black Mountain Road.
Let's be clear. That's who's the fee owner of that property?
Well, the fee is owned by the Davis family, but it's subject to an easement.
Okay, so there's an easement across the Davis' land.
Right, and it's exclusive. It's an exclusive easement, so nobody can interfere with that driveway.
12 feet wide.
And I'm going to come at this 3 ways. There's a detailed memorandum submitted to the town, which has a lot of technical language in it, but I think I can distill that to a fairly common sense explanation. The denial stems from a note that was put on the plan by the town's engineer, Burr Phillips, on the septic approval, saying that I don't think this lot's buildable because it doesn't have street frontage as required by, and it references the applicable statute. Okay? Well, the problem with relying on that statute, and what Burr is talking about, is that this easement is a street that doesn't meet applicable standards for a street. Okay? So his position is that this driveway is a street, and the lot fronts on the driveway, which doesn't qualify as a street under Jackson ordinances. But that analysis is incorrect. The easement is not a street, it's a driveway. Okay? And our memorandum was established that quite well. If you read 674-41, it says that all lots must have frontage on a street that meets applicable standards. The town has looked at this and said, well, this lot has frontage on the easement, which doesn't meet applicable standards. But the lot doesn't have frontage on an easement. The easement is part of the lot. Okay? The easement specifies that it is appurtenant to the lot, that it goes with the lot. New Hampshire law is very clear that the easement goes with the lot. The state statute does not define a street, which means we have to default to the local definition. The easement does not fall within the definition of a street under the Town of Jackson zoning ordinance. It clearly falls within the definition of a driveway. Okay? So this lot includes the easement area. The driveway is located within the easement area, and that driveway has frontage on Black Mountain Road. So the legal analysis underlying the rejection is incorrect. That's our first argument. Our second argument is that this is a grandfathered non-conforming use. If we assume that the town's denial is correct, that it doesn't have frontage on a street, then we take the position that this is a grandfathered non-conforming use. The lot has, since 1959, been taxed as a building lot. There was a seasonal residence located on it for a fair amount of time. There is water serving the property. And once a lot is established as a residential use, subsequent changes in ordinances can't deprive the lot of that grandfathered status. That's why we have a grandfathered clause in every zoning ordinance and every part of the state law too. And the reason we have grandfathering is because the adoption of statutes which deprive people of property rights represents a taking, and the owners have to be compensated, which of course never happened here. So that's the second position. And the third position is that the town, I think, is stopped from denying that this is a building lot. This had been presumed as a building lot for many years. It wasn't until June 3rd of 2010 where a note appeared on the septic plan saying that the lot was not buildable because of the driveway issue. Okay? The property owner immediately went to the abutter, the Davis family, and obtained an easement deed. That easement deed was accepted on July 1st, about a month later, and recorded on July 23rd. Now, if the town, based on that June 3rd note, determined that this was not a buildable lot, it should have then stopped taxing the lot as a building lot. But the town did not. And the reason the town did not stop taxing this as a building lot is because a deficiency in the access was pointed out to the property owner. The property owner then resolved that deficiency by obtaining an easement deed, granting it access directly to Black Mountain.
When was that deed granted?
No, it was recorded July 23rd. It was dated July 1st.
Of what year?
2010.
Okay.
So the note on the plan is dated June 3rd, 2010, which states that there wasn't frontage. The easement deed was obtained on July 1, 2010 to correct that defect. So that note that appears on the septic approval plan, which started this whole thing, the genesis of it, was placed there at a time where there wasn't easement access to this road. So the property owner, in reliance on that statement, approached the abutting property owner, secured an easement deed a month later, and recorded it. And after recording it, the town continued to maintain its tax status as a residential lot. So in other words, the deficiency was pointed out by the town, the property owner acted on it, the town continued taxing it as a residential lot. So that third defense is an estoppel issue, and down the road if something were to happen on it. So that's, I rest my case.
And a couple of questions.
Shoot.
This, of course, is, well, as you mentioned 67441. How do you address the issue that in 67441 it says, for the purposes of paragraph 1, quote, the street giving access to the lot means a street or way abutting the lot and upon which the lot has frontage. It does not include a street from which the sole access to the lot is via private easement or right-of-way, unless such easement or right-of-way also meets the criteria set forth above.
What they're missing there is that this easement is pertinent to the lot and is actually part of the lot. Okay? What they're talking about are private roads that travel a distance, but this easement is pertinent to the lot. And it does not, and moreover,
Well, why do you say that?
That mentions street, it doesn't mention driveway. This is a driveway.
So if that were true, every lot that has no frontage, if it had an easement for a driveway, would qualify as a buildable lot.
It would depend on the nature of the easement and where it's built and how it's...
Only because this is a grandfathered lot, otherwise.
Yeah.
Is that, you're using the grandfathered lot status?
If you look at everything taken together, I mean, you know, it's clearly grandfathered, it's been taxed as such.
But all lots that pay taxes are within the considered. I mean, it's
Well, it
very
depends on
broad.
how they're
Well, it
taxed.
depends on how they're taxed. It's taxed as a building lot. That's what it's
But in
saying.
Jackson, historically, a lot of
Yeah.
stuff got taxed as a building
Building a
lot.
lot until they try to build on it.
Doesn't matter.
And that's a whole other case.
Yeah, I mean, that goes on here.
It's not
I'm
an
still not sure I
argument.
appreciate the argument you're
I
making,
don't either.
because it seems,
No.
I mean, I don't have the statute.
You want it right here?
I have a
Oh,
statute.
out the book.
I have a statute.
Where is it?
641.
Yeah.
Keep going.
No, where's the addition?
Next page. Right there.
It was done in,
See, this simply says the street giving access to the lot means a street or way abutting the lot and upon which the lot has frontage. And then it says, it does not include a street from which the sole access to the lot is via a private easement or right-of-way.
That would be a street located on a private easement or right-of-way. This isn't a street located on a private easement or right-of-way, it's a driveway.
I think we're.
If
Okay, so, okay, that's the second question then. Though, we're of course the Board of Adjustment.
Yep.
We can interpret the zoning ordinance. We can grant waivers to 67441. But I'm also not clear how we have standing to actually
change the law.
make an opinion, come to an opinion about whether or not the town is properly enforcing 67441, or even what 67441 means. That seems like it's outside our jurisdiction.
I mean, interestingly, the town of Jackson, and I do a lot of municipal work, is the only town that has ever interpreted 67441 the way this town interprets it. And that,
yeah, but my question was the question of standing. I mean, not standing, whether or not we have jurisdiction to even consider this.
we certainly do. I mean,
Well, the town's denied a permit based on a state law, citing a state law.
that's right.
We have the ability in the ZBA to grant a waiver,
No exceptions.
an exception, which you have not yet asked for.
Yes.
But I don't see how we have the authority to interpret whether or not the town is properly applying a state law, which is the question. We certainly have a right ability to grant variances from the zoning ordinance, but this isn't the zoning ordinance question.
Well, you have the ability to determine whether a building permit was improperly denied. And the denial of this building permit was based on state law, which is the jurisdiction.
Improperly denied in connection with the zoning ordinance.
Well, we're interpreting part of the zoning ordinance in any event because we have to determine whether it's a street or driveway. And that's within the town of Jackson zoning ordinance.
So we use the zoning ordinance definitions to define what is applied in the state law? I mean, to interpret the application of the state law? That seems standing things on its head.
Well, if the statute, if RSA 674 had a definition of street, we would be relying on that. But it is not a defined term within the statute, which leaves you looking to the municipal definition of what is a street, because that's the only place there is a definition. And this really does not fall within the definition of street under the town of Jackson zoning ordinance.
I have a question.
I'm sorry, go ahead. I didn't mean to monopolize.
641 also clearly says there's no grandfathering under that state statute.
Right.
It supersedes all other, and supersedes town ordinances. So I'm a little bit confused about the grandfathering aspect of your argument, because the statute says there is no grandfathering under that statute. It supersedes.
Well, if the town has continued to tax it as a residential building lot, even after it's pointed out the issue.
That's not for this board to decide the tax issues. I mean, as an appealed administrative decision, we have to stick to pretty literal interpretation of the law. We're looking at state law, and it says there is no grandfathering. So I just wanted to clarify, your grandfathering is under the Jackson zoning ordinance,
right.
But it's not under the state statute.
That's right.
641.
And I don't think 641 applies. 674-41 applies.
674-41.
I just don't think that it does.
The other question I had for you was 674-41 allows someone to come in and say, even if you believe it applies, I want exceptions. And you didn't ask for exceptions on this.
Well, I can ask for an exception right now, but I just don't think that it applies is our argument. And if it does apply, I think an exception should be granted because the town of Jackson has historically treated this as a residential building lot. You know, in fact, when this deficiency in access was pointed out, the property owner took action on that. And following that action, the town continued to recognize this as a residential building.
Yeah, we don't get into taxing and
I know,
that
I don't get into
stuff,
taxing.
That's interesting, but that's not something we can look here.
Well, it's factual and it should be here because that's how the town has regarded this law. That's very, in fact, it's conclusive evidence as to how the town has treated this lot as a building lot. And what we're talking about here is not just the driveway, it's whether this lot is buildable. So if the town, on one hand, is saying it is buildable, and pretty unequivocally so, even after changes were made, I don't understand how the ZBA can then make a determination that it is not buildable. I think that's something you probably can't do. You know, if you're troubled by the grandfathering status, there is the estoppel argument that anybody can rely on the actions of a town. And when an error is pointed out, and someone takes action based on that, and the town continues to then recognize it as a residential lot, you know, if the owner relies on the town's pointing out deficiency, and the town continues treating it as a taxable lot, the owner is entitled to rely on that going forward.
And what are they entitled to, other than the fact that they were overpaying their taxes, say, because it was a non-buildable lot?
Well,
what else are they then entitled to anything they ask for? I just asked the question.
No, it's a building lot. Once you get beyond the building lot status, whatever zoning, setback, and everything else as it exists within the town. If you know, for the record, if you'd like to approach this as a waiver, I would request a waiver of this. And the basis for that request would be that the owner has, in good faith, made changes in its ownership consistent with the town of Jackson zoning ordinance and its grandfathered status.
Well, if we were to get into the exception area, there are some specific criteria we have to
Other
apply.
criteria to
You
look
may
at.
have to ask for more information.
Yeah, I
to get to that
mean, we'd
point.
probably adjourn,
Continue
continue the hearing and let
Because
you
it would be
provide that
If you'd
information.
like to do that, I'd be happy to do that.
Well, I think there's I guess I have, I mean, I'm not, you've heard my concern. I'm not sure we have jurisdiction for the argument that he's making. Actually, well, let me step back for a second. We're in a public hearing, I should let others speak.
Right. Should
Now
get
that-
the butters
Now
and
that we
stuff.
understand his position. And we'll ask you, or give you an opportunity to make further statements after any abutters make any statements. So, Ken, do you have anything else to say at this point, or?
No, I don't. I'm happy to respond to
Okay.
questions.
Great. Well, since this is a public hearing, any directly affected party or abutter has an ability to speak and comment on the request of the appeal. It sounds like, Bob, you're about to say something.
If you're going to turn this one down, there's an awful lot of situations, just like in town. The adjoining lot, what's that lot, was subdivided maybe 10 years ago, got no frontage. It's the same situation. There's one up the road, quarter of a mile, 3 houses on the driveway. That's it, no frontage. And that was approved 15 years ago. There's a lot of lots around town. It's the same situation. Every time they change hands, you're going to circumcise them and say you can't do it. Can't sell it.
Got a question?
Linda.
Go ahead.
Demo.
I just want to say, as the next door neighbors, that we would be delighted to have someone build a house next door. We live in Gene Norris's old farm, and I think we're in the same situation, right, Bob?
That's right.
We're in the same situation where Bob owns the land on the road, but many years ago, I'm not sure when the lots were all divided up, we have only a driveway access to our property, and I hope I'm not opening up a can of worms, because at some point we're going to want to sell that house. So, but as far as having a neighbor and, using that bridge to get onto their property, I can't see why you wouldn't allow it. And I know there are a lot of rules, but somehow a waiver has got to be given to them.
Yes.
Was just coming. I see the property line was incorrect because it was close to my porch. My husband bought in the house.
Excuse me, that's a different case. We haven't heard that yet. This is...
I know this is very small lot.
No.
It's a different case.
The different case.
Later on. Oh, sorry. Thank you.
Are you an abutter, Jerry?
I'm not a butter, but I'm a property owner in Jackson. I'm affected by these rules.
I don't know if I have standing by itself.
You don't, well, our rules really don't allow you to speak, but I'll let go, given your prior role in planning board, I'll go ahead.
I think your interpretation of 674-41 is correct. I think the attorney's explanation of it sort of walks around it. I think that there are some options as to how they can do this. One option would be to have the planning board, and the planning board has this right, to declare it a street instead of an easement or a driveway. Another way to do it would be to have the selectmen waive. The selectmen have the right to waive with consulting the planning board the definition or the requirement of the 200 feet. There is also a recent case, Atkinson v. Mulberry, where the fire inspector or fire chief can require sprinklers to the house if the road doesn't meet the requirements that the town would have for a normal street. So there are options outside the ZBA that the applicant could take that are prescribed by law and court cases. And I think more directly that your interpretation of 674-41 is correct.
Ken, you have...
I just want to respond to sort of general comments. One of the reasons we came in this way is that we aren't making a policy decision here. This is based on one lot. The ZBA doesn't establish precedent by making decisions. And the facts of this lot are unique in that there was no access, there was a meeting at the town, and then access was obtained. So unless somebody falls exactly within those four corners, any decision that's made here tonight doesn't mean anything with respect to property throughout the town.
I think my understanding, and actually I was present, when the selectmen denied the permit and suggested going to the ZBA, I think that was done with the expectation that you would be applying for an exception.
Yeah, that's the correct
and not making the argument that you're making. So.
Because I don't think we can do what they want us to do
Well,
without an appeal.
With deliberations.
Yeah. So I'm going to. Well, I'll keep the public hearing open while we talk, just in case we want to have other questions. But B, you.
So in other words, they can come back and ask for an exception?
One possible outcome, which we're about to discuss, is to keep the public hearing or postpone the public hearing to our next meeting. Give Ken the ability to prepare an argument for an exception, as this board actually has done in the past, and then see if we can come, whether or not we can do that. And there are some very specific criteria on which we can grant the exception. We have the ability to grant conditions to that exception. That is one way, and as Jerry said, there are other avenues as well. I think all will struggle with the same things we'll struggle with in terms of, is a 12-foot easement adequate, or and in terms of access and so forth. But I guess the issue is, what should we do now?
I just wanted to say that, I looked at 67441. The thing that made the most sense to me was that it's a way to regulate road access adequately for the town. And I think that's the problem with just an easement onto a road. It's 12 feet. Is it sufficient? And I think Bob Davis is right. There are other lots that are going to face the same issue. And so we have to find a way that these people can have their property rights but have adequate road access. And I think that's why the statute is here, is to put a stop in this and go to the planning board, could come back here and ask for exceptions, at which time we could impose conditions, and they will be. It doesn't even meet the driveway conditions in Jackson. Why would we let that happen? So I think if we could rule tonight on denying it and suggest they come back with either to the planning board or to us with exceptions, or they can suggest that they go back, rethink it, and come back to us with exceptions. So I think there's kind of a choice here, and that's a little bit what the rest of us feels would be more adequate than what Mr. Evans wants to do here.
Dave? It doesn't sound like we're going
in the same direction. I think that argument is valid.
Yeah. So we should.
What would you prefer? Would you prefer us to rule tonight and then come back?
I would like to. We've been. Well, I would prefer a meeting be continued because I have some concerns about the timeline here. I don't want to risk the timeline because you have to appeal from the decision of the administrative officer, your building inspector, a certain number of days.
Right.
Well, if we rule tonight, you have to do 30 days.
What you have to do is do a motion for rehearing. It's easier just to continue it on the record and bring up that issue later on.
Yeah, and plus it would give us an opportunity to at least consider your arguments as well, in terms of your interpretation of 67441.
Would this be a meeting with the planning board?
No, this is simply, we will, what I'm suggesting is that we, I'm not quite sure what the right word is, adjourn? Continue the hearing until our next meeting, and in which case you'll have, prior to that meeting, you'd provide us with arguments about why you should qualify for an exception, which the ZBA can grant, and we'd consider that at our next meeting.
Sure.
At the same time, we will do our own research in terms of the arguments you've raised.
Okay.
He has something to say.
Yes, Pete.
Joe said we gave them a 12-foot right-of-way. It was a 30-foot right-of-way.
I think we'll,
I don't know.
I thought it was smaller than that, but
Well,
it does not matters.
that I'm sure really matters tonight, but it'll be again the adequacy of the driveway or street or where we get into it, and there will be conditions.
Yeah.
The limit was the improved surface has to be 12 feet, but the easement itself is wide.
Yeah.
Okay.
So
That's what probably the 12 feet came from.
that's what, yeah, and it just says improved surface is 12 feet.
And of course, one issue is how wide the bridge is at the moment.
Exactly.
We'll get to that.
I mean,
Yeah. Okay.
The only other thing is the only one time we addressed this issue, we also requested a waiver of liability of the town.
Oh, that goes what I'm saying.
Okay,
Yeah.
just so that's out on the table.
Yes, Jerry.
Should it be noted that the request for rehearing is at the applicant's request?
Yes.
Well, actually, we're continuing the hearing. So, which,
I just meant in case any timelines were involved.
yeah, we're simply continuing the hearing, so we're not going to have to notify the abutters again with certified mail. It's our next hearing. Well, we'll make it the next second, whatever the next Wednesday is
In June.
June 15th or something.
The second or third Wednesday.
It's third Wednesday, right? So we continue the hearing to June 19th.
Okay.
We do have a rule, we want the materials submitted 7 days in advance, so it can be distributed, preferably by soft copy, electronic.
All right, where should I send the
My email address, which I know your other guy, what's her name has.
Becky also has your email address?
Yes.
No.
Okay.
Good old what's her name.
Good old what's in there.
And we'll look very close. I mean, we will pay very strict attention to the criteria that are listed, that were in the original email I sent.
Okay.
On granting exception.
Okay.
Great. So,
Vote on the continuance?
pardon?
You will have to vote
Do
on
we
that?
need to have a vote on that?
No, I don't think we do, because it's continued.
Okay.
Our minds are not made up, so there's something to vote on yet.
Okay.
All right.
So with that, I'll.
Well, you should, on the continuance itself, there should be a motion to continue this
That's
on
what
my
I- that's what I
request,
thought, yeah.
and vote in favor of the motion, so it's in your minutes.
Yeah.
Okay.
I'll make a motion to continue till June the 15th.
The hearing.
On the continuance, yeah.
Continue this public hearing.
Continue this public hearing to June the 15th.
Okay.
June the 19th.
Second.
Second.
All in favor?
Aye.
Motion carries. Okay. That takes care of the first public hearing. What would you like to do next?
That's up to you.
Okay. Well, the agenda had the selectmen's motion for reconsideration of the appeal of variance granted to Rupel as the next agenda item. So we'll take that up. This is part of the meeting is not a public hearing. It's simply a public meeting, which means we won't be taking testimony or comments. It's simply a discussion among ourselves on the motion as filed by the selectmen. We'll make our decision and then go to the next public hearing. And for those of you who aren't familiar with what a motion for rehearing is, this is a prior case in which we decided we granted the variance, and the selectmen or any of other can file a motion for rehearing, which basically is asking us to take another look at the arguments in the motion for the rehearing, try to decide whether or not we made a mistake or not, or there's new evidence. If there is, in granting the motion for rehearing, we basically start all over at the beginning and require the applicant to, and the abutters to go through the same process.
Clarification, please.
I'm sorry?
Clarification, please. What you're about to do then is to decide on whether or not you will grant a rehearing.
Yes. Yes. And I will just point out that we're not required, we should use our judgment in deciding whether or not justice is so served by doing this rehearing. The rehearing, we should grant it, if we think that we've made an error to the detriment of the town, or the town has produced new evidence that was not available at the first meeting. But we should, I think, pay less attention to evidence or arguments that could have been made at our first hearing on this, but were not, for whatever reason. And I will leave it at that. So everybody has our published decision on RUPO, as well as the selectmen's arguments for why it should be granted.
Rehearing.
And I think the selectmen via Andy make 3 or 4 points. So should we just go through this one by one, or?
That's fine by me.
I think the first argument that is being made is the town may bear liability for damage to the structure during normal road maintenance, snow removal. And construction may undermine the road surface since it's close to the road.
When I look through the minutes of our deliberation and our decision itself, we did talk a little bit about the health and safety aspect of this appeal, but we didn't elaborate it on a lot. But in our decision, we clearly state, I think I get to the right page here, that one of the conditions that we imposed was that the building inspector may impose additional requirements given the proximity of the excavation and travel, and may request bond or whatever to remedy it. So it seems to me that the town still has a path if they're concerned about the excavation part and undermining the road, that our decision gave them the right to impose conditions on building.
And they have the right anyhow through the site disturbance or land disturbance ordinance, plus the building code requires engineered retaining walls in excess of 4 feet, I think. So it seems to me that's a building code and zoning ordinance issue. It's not an issue. Whether that's a steep slope and it might slide, it's not an issue that we should have worked on anyhow.
So I think Dave and I are on the same page. There's another way to address that particular concern that's clearly available to the town.
Anybody else?
The next one.
Did we also at some point say that he was to have the reference that the town had no liability? I think we mentioned that very early on, but I don't think we thought it on that.
I don't think it's in the decision.
No, it's not.
So I don't know.
And to be clear, what's before us now is to say yes to this.
Right.
No.
But we're trying to decide if we erred.
Yes.
So,
did we err?
Did we err?
The other thing that Andy mentions in his letter is could block the sight lines of the road. I don't see how it could possibly block the sight lines.
That's
I went
fine.
up there
Let's take one.
yesterday.
I've been up there several times.
And the
Line
trees-
driveway has been, yeah.
The trees there are 30 feet high, and the highest point of the garage can only be 2 feet above the surface of the road. That's maximum.
But you know,
But
in
if
any
I was
event, you
sitting
wouldn't
at
be
4
looking
feet.
through the garage.
Right.
Right, but
Right.
you're sitting at 4 feet above, so there's absolutely no way that could, and it's also totally to the right-hand side of the road. There's no line of sight.
And you're not going up or down, right?
Are you backing up?
If you're going, if you're seeing the garage, you're in deep trouble.
Right.
Well, it wouldn't, the location of the garage, it seems to me, has nothing to do with sight line on the road.
Right.
Yeah.
Yeah,
Right.
absolutely.
So I think those are the arguments he makes in paragraph 2 of
And this is in reference to
his letter.
the criteria that the spirit of the ordinance must be preserved.
Right.
Or is observed.
Item two, yeah, okay.
Again, I think the town has other options to address his concerns, some of them through
Yeah.
the building
Okay.
I don't think
code
those should
flow
have been.
and our decision. So then number 3, substantial justice.
Okay, well, so let's go through this point by point. So nobody feels that the arguments here suggest we made a mistake
In 1 or 2?
in 1 and 2,
Yeah, I know.
in identifying the public interest.
Well, and we should, I'd like to point out that we talked about what was we had to decide what the purpose of the ordinance was.
Yes.
Because there is no purpose set forward. There was no purpose stated when the ordinance was
Enacted?
enacted. There was no purpose stated. So we figured out what we thought the purpose was, which is what we're supposed to do, and couldn't see that citing that garage where he wanted to cite it
Would have impacts on density.
wouldn't have impact on the purpose of the ordinance.
Yep.
And the purpose of the ordinance was, so, just for the notes.
Density.
Density,
Rural characteristics of the town.
yeah, rural character, density.
I mean, in spirit of what the selectmen are doing here, are they pointing out issues that we did not consider or that we feel violate the spirit of the ordinance? And I think we're saying,
Or that would change your mind.
yeah.
Had you known
Had you
that,
known that,
had you known that, you would have voted differently. That,
And I'm,
So that would be new information that wasn't.
yeah, that's, which there isn't.
Yeah, that new
It's
information.
it's an interpretation of the information that was already there.
Yeah,
So I'm hearing consensus that
yeah.
that doesn't work.
given that they still have ways of addressing those
Yes.
very issues.
Yes.
That zoning ordinance is not, 50-foot setback isn't the only way to address those issues.
Right.
Now,
Probably
the
not
third
the right
point
way at all.
Yeah, but
is
there are
on
options.
substantial justice. He's stating that the potential benefit to the applicant outweighs the potential harm to the general public.
He doesn't list what general harm is to the
Well,
public.
I'm presuming it means the things he's talking about first. I think the big issue here is this is turned upside down. The substantial justice test is whether or not the harm to the applicant outweighs,
That's right.
is outweighed by
Harm to the
the
public.
benefit to the public.
Agreed.
So it's the harm to the applicant, not the benefit to the public.
Right,
And it's a benefit to the public, not as Andy says, the harm.
right.
So I don't
Reverse.
think this is actually relevant at all to that specific test.
Right.
The fourth point.
Justice.
Comment, the neighbors all came and supported it, which is
Well,
a very
that's-
strong.
that's
point.
the fourth
That
point.
has more to do with the value.
Is the values of the surrounding property are not diminished. The appeal states that they saw no testimony to support an argument either for or against. In fact, there were many of others, I think three, if
Three
not
or
four,
four.
Yeah, that all said they had no
who
problem.
were present at the meeting and spoke strongly in favor for it. So I think they just missed that part of the minutes.
Well, it's also clear that we're supposed to and allowed to use our judgment and what we know, and anybody driving up there that would say the value of surrounding property would be reduced because somebody puts a garage next to their house. That doesn't fly.
Okay, then the last argument is the hardship argument, and they're making the point that the Ruppel could have put the garage elsewhere on the property. And
can I speak to that?
Go ahead.
There seems to be it seems that the thought is that if you can put it someplace else and it doesn't require incursion of a setback, and if you have the ability to use your property, then you can't get a variance. But when I read the statute, which we all have in our books on the ZBA, if there's something about the property that distinguishes it from other properties, which there is in this case, because it's the only property in that entire development that has that two sides covered by a road. So there's no question that in that development that's a unique piece of property, and it distinguishes it from other properties. And then it says no fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property. And we talked about that, and we thought that there wasn't. And the proposed use is a reasonable one. And certainly a garage and a residential is a reasonable use. If those criteria are met, then what this is saying, you should grant the variance. And I think those criteria were met. If neither of those, and if none of those criteria are met, then it's a matter of reasonable use of the property.
Yeah. I agree with you. I think the fact that Ruppel could build the garage someplace else is not material to that prong of the variance test.
That's
essentially what you said. That if the purposes of the setback applied in this situation, balancing the public benefit versus the harm to the applicant, we found very little. Again, thinking that setback is view and density and similar things, that there's very little
rule of character.
I'm sorry?
I'm just mumbling to myself.
How did you do that? Frank, didn't one of the abutters even say that they thought it would enhance the value of their property if this thing were buried up against not buried up against, but moved back against
yes,
where it was,
And that's a fair point. I did try to. I was troubled by this, so I did try to reach out to an attorney, and I did have a brief conversation with Christine at the LGC, and she was unable to offer an opinion.
Really?
Yes.
I find that strange.
It was a close call, but that she was very comfortable with the thought process we went through, and didn't. I hesitate saying, I hesitate kind of telling things third hand, but I reached out concerned that just the pure fact that somebody could build something someplace else negates any consideration of granting a variance. She didn't feel that was an issue.
She didn't call you a jackass.
So I think what I'm hearing is consensus that we should deny this motion.
That would be my
think you should vote.
Yes, so I could have a motion then to that effect?
So moved.
Seconded?
Seconded.
All in favor?
Aye.
Who voted? 1, 2, 3, 4, 5, okay. So it was unanimous. Great.
They have other options, don't they?
Yeah, that's what he said.
Yeah.
Okay. Next comment is Black Mountain Road. Yeah, we just had one.
Just did one.
We just did Black Mountain
Spring
Road.
Street or Francis Street?
I have Bollinger next. Shall we, is that okay?
Fine.
Okay. Next, we'll turn to the variance request. I meant to say we had public notice and on Evans, and we got all the cards back and everything. So I'll now open the public hearing on Bollinger. As before, this is a situation where the applicant has a chance to make a presentation. We get to ask questions. Other individuals in the room who have are butters or are directly affected by the variance have an opportunity to speak. The applicant may be able to make a rebuttal, and then we will consider the request. So, open the hearing.
Can we?
Yes.
Okay, open the hearing. I just have a question. Oh,
Okay, I've opened the hearing.
Which street is this?
This is
Spring Street.
6 Spring Street.
My question is, do we feel that if he wants to expand the space of this dwelling by putting a foundation under it, that's not a subject, or in other words, that's allowed, even though it might double the space of the building?
In the same footprint that exists now.
In the same footprint that exists now.
Well, first, before you get to that, let me just for the record say that people were notified, the abutters were notified. We have 3 of I think the 4 responses. I will give you the names later or fill them in myself. So there's public notice.
The only reason I mention that is I just didn't want to get into talking about an expansion of a non-conforming building or something of that sort.
Well, I think
on the basis of the basement.
Well, let's. Is Brad Bollinger here? Yes. Okay. Well, you get a chance. You have a chance to come up and talk.
Great. Thank you.
I suppose the first thing we have to do is make sure we understand what is being requested.
Yeah, that's good.
My understanding is that the roof line is proposed to be increased. So,
yeah, if he squares it off, that's right.
Yeah. So he's expanding. You're welcome to sit down. You need not to stand.
Sure.
He's expanding the volume, but if somebody is simply keeping the existing building envelope and in the end just ending up with the basement or something, but the building heights and everything are all exactly the same, that doesn't have any zoning impact, I don't believe.
No, it doesn't. That's why I want to make sure we're on the same page.
But to the extent he builds into any prescribed setback or increases the height,
that's different.
In the prescribed setback area,
right.
Then it would be. So, Brad, why don't you? I think we've all seen. We all have copies of this. Okay, you can have this copy. And I do have 8x10 color glossies.
Suitable for framing?
Suitable for framing.
I did my
you
best.
pass those around.
That's a good snow year.
So
I'm happy to sum it up.
Yeah, why don't you, it'd be helpful to first understand exactly where you're expanding into the prescribed setback, either in plan or in elevation?
Sure, absolutely.
From a volume perspective.
Yep. So the ultimate goal of this, I have my property's on piers, on actually old telephone poles. The previous owner worked for the electric company, and the 4 additions that were put onto this structure were put on telephone poles. So my ultimate goal is to be proactive about this before it falls down and put a firm foundation under it. Now, as you can see through the photos and the footprint layout on the survey that was done by Amanuensis Survey, you can see the southerly side of my property, the bathroom and utilities region was added onto. It looks like at least 3 times and has 3 or 4 different roof lines. So again, trying to be proactive, I'm going to have to lift this building to put a full foundation under it and to do it properly. So in doing that, my hope was to push off that wonky bathroom end of the house, which is on the other side from the deck. You can't quite see it in those that you're looking at, but, and square off that end of the building. So the footprint would indeed be expanding inward towards the center of the property, which is where the buildable area is. And we can come back to the buildable area discussion because there are some vast discrepancies in my deed and the proposed subdivision of the property by as much as 20 feet. So that's maybe another discussion. But so my ultimate goal is to get rid of that wonky end of the house where the bathroom is, square it off, so I make a square structure, more or less, making the foundation a lot easier to put in, obviously, excavation, et cetera, et cetera. That's the footprint side of it. The roof line, I hope to take the 5 various pitches of roof and put it to 2. There's a main roof line that comes down on the main portion of the building, and then a flatter section of the roof that sits over the kitchen. So my goal would be to get rid of all those roof lines and make a more consistent roof line.
And that roof line would be as consistent with the current height?
Yeah, so that's my goal. So one of the struggles is, of course, when you put a foundation in, you don't know what you're going to hit until you start digging. My goal would not be to lift the house really any further if I could avoid it, because already on the driveway side, which is the west side of the house, we're already looking at floor heights about 4 feet above grade to the kitchen level floor. So even if I wanted to bump it up anymore, it would look horrible, and it's not my intention by any means. My goal is to keep it as is, though again, until we start excavating under it. I mean, we could hit a big boulder there. I have no idea. So my intention is not to raise it, period.
Will you be adding a loft or second floor to the home?
No. In the section above, I don't know if you can tell, above the bedroom there's already a knee-high loft up there that is used for storage. It's been there forever. My goal is not to extend that or make that any sort of living space. In fact, I sort of wish I could cathedral it out and get rid of it altogether. And it would be a viable option if I actually had storage space. As it is, there are no closets in this building. So I would love some storage space underneath in the basement.
When you're talking about redoing the roof, to meet current code, will you be changing the height of the house? Because is it right now your lowest point in the inside roofs?
Yeah.
That was already asked.
That was already asked.
Yeah.
It's not going to be any higher than the current is.
I'm asking right now, how high are your roofs inside your
my
building?
ceiling.
Your ceiling.
My ceiling.
Ceilings inside your house right now, and to meet current code, will they have to be higher? In other words, a lot of those can't be 7 foot high.
Yeah.
But code says now, 82 or 94, whatever the inches are, I don't know. But will you have to raise them to meet new code and therefore increase the volume more, is my question.
I don't know the answer to that. That's a good question. The area in the bedroom is at least over my fingertips, so it's not a low ceiling by any means. The kitchen is a little bit lower based on the angle of that flatter section of roof, but I don't know the answer to that specifically. If I had, I think I know what you're talking about. I think what I said is, if I had to move my building so as to set it in a situation where I could put it in close proximity to the buildable area as set out by the survey, it would be on top of my septic.
Yeah.
So I don't, So one thought I had in this process was, oh, well, I'm going to lift the building anyway. Why don't I just move it towards the center of the property where the buildable area is? Well, that's right on top of the septic tank. So I didn't see that as a feasible option.
Did you get a clarification from Andy Chalmers about the septic, whether it needs to be brought up to code or whether?
So, and this is a discussion Frank and I had. So when I first talked to Andy about this, when I put the initial building application in, I said, Andy, I'm just trying to understand what I need to do for this. I'm not adding bedrooms. I'm not adding bathrooms. Do I need to do anything to my septic? My understanding was that I needed to do nothing. So I didn't. Frank, in his follow-up to my ZBA, my variance application, said, oh, where's your septic design? I said, I didn't know I needed one. I followed back up with Andy. He clarified it and said, oh, there's nothing on file. You will need to have a septic design created. And so I'm talking to Amanuensis Survey about completing that at this point. So as that stands, I know I'm remiss in that aspect of this application.
Did he tell you whether it's just a matter of showing the design for what's there, or whether it needs to meet current codes?
I haven't been able to get clarity on that at all, and that is certainly a huge component to my own decision-making process, because this is a 0.21 acre lot. And so I don't have a lot of options, and I don't have endless amounts of money. So if I have to put a new septic in, I may not be able to do this project, period, which means my house stays on piers. And certainly I don't want that, but if that's the law, that's the law. I haven't been able to get clarity, and that's one thing I was hoping to understand tonight.
We can't, I'm not sure if we're going to say anything about what you need on septic.
Okay.
That's not part of our...
No, I was curious.
Yeah.
But should we be giving people variances if they don't have septic to provide?
I don't think it's part of our...
That's not part of our thing. We're addressing the setback. That's the reason for denial.
How about...
Is it Andy the one that is supposed to clarify that?
Andy and Burr Phillips are probably...
Burr Phillips?
Yeah. Burr Phillips would look at a design.
Okay.
If it needs to be current, he would approve it for the town.
Okay.
The state would approve it on the state, but our case are tough.
All right, I'll discuss it further with them.
Okay. Well, one question I have is, the zoning is intended to apply to everybody equally. And when we grant variances, as you've requested here, it's because there's something unique about your property, uniquely different from your surrounding neighbors. And I'm kind of struggling to understand where that uniqueness is in this case.
He has a unique problem, isn't it?
I have a question about Spring Street. When I look at these drawings, I say, why is this dead-end chunk of what appears to be Spring Street, although they haven't used that in a 40-foot, they haven't done any drawing the setbacks around it, or the 40-foot right-of-way around it. Why is that there? What is it?
So Spring Street takes that right, and on my deed, that right-hand turn is actually called Jackson Avenue, I think, and it feeds the 2 or 3 houses down that avenue.
If you look at this, I'm talking about the little square section.
So that's Spring, right? Here's my property.
Right.
That's Spring, my driveway.
That's your driveway.
Yeah, this is my drive.
Okay.
Yeah,
I got it.
and then this turn
okay.
feeds the 3 properties down.
That wasn't identified as driveway. I thought that might be part of Spring Street.
Gotcha. Okay.
Okay.
So I think the uniqueness of this property is it's less than a quarter of an acre. It's constrained on 2 sides by road frontage, although it's non-maintained by the town. It's a Class 5. Nobody touches it or plows it except the property owners. And then as such, I have 50-foot setbacks on 2 aspects to a 0.21 acre property, which means I can't do anything to my property as it stands.
Are there other lots here that are that small?
Not that I'm aware of, but...
There's a lot of small lots, but I believe that is the smallest in that area.
And so, also, the updated surveys that I sent show the lot bounded by the 40-foot right-of-way as by plan, and shows how drastically short of my property footage that could be according to my deed. So on the northern aspects, we're talking 16 feet shorter is what that road right-of-way allows, technically, for my property. My deed says I'm actually supposed to have 100 feet on the northern aspect, and according to the right-of-ways, I would only have 84. Again, on the eastern aspect, my deed says 116, or I think it's 116, and we'd be actually only a couple feet short on that aspect. But 16 feet on the northerly aspect changes the dimensions of my lot entirely and changes my buildable area pretty aggressively. My building almost falls within the buildable area if we use the deed dimensions of my lot, not the plan right away around the street. So, and this is Frank answering to why M-Music survey only said this was a preliminary survey, is because there were such vast discrepancies they weren't willing to sign it and make it final.
You say your deed shows a larger piece of property than...
Yeah, if you see, this is the survey. The dark black line is what my deed shows. These pins were found.
Okay.
This is what using the right-of-way delineation would allow me. But if we went off what the deed says, this is my buildable area, which is almost inclusive of where I want to build.
How does that change? Because the right-of-way is still a right-of-way. Or you're saying disregard the right-of-way, forget the right-of-way?
Well, there's just a vast discrepancy, and I don't know what we go off of.
Go off the deed, didn't you?
I would assume.
I would think you would go off the deed, but what happens to the right-of-way then? It becomes not 40 feet there, is that what you're
Potentially.
saying?
But and I asked M-Music survey about that, and they said, well, where the road actually isn't necessarily where it was intended to be, so your right-of-ways could be wonky to begin with.
Right.
Though, that said, I don't believe between my property line and this easternmost boundary line, I don't think you get 40 feet out of that any day of the week. So this is one of the struggles, is that there's just...
Yeah.
I don't know who's right or what's right, and so these are some of my struggles.
Some of this stuff was really pretty sloppy on these older subdivisions.
Well, they're all meets and bounds that are used anyway, so if someone moves a boulder, your property's smaller. I mean, it doesn't matter. A tree
In a
falls
way,
down.
this is sort of like North Hampshire Ridge in that you're hemmed in on two sides of the road.
Yeah, but here all the properties are about the same size.
Okay.
Yeah.
Many of them are 0.3 acres rather than 0.2 acres. But
Well, and if you look at the subdivision, I mean, it goes in circles, so you've got several properties with the same kind of situation.
Another quick question: are the other houses up there built on piers as well, or is yours unusual?
I believe that the southern property is built on a foundation. I'm not sure what the Chipmans is built on, the northern property. It's a little bit lower. I don't know if there's a full foundation
of
of
those
that.
lots that have been built, right?
Yeah, there's I think 3 beyond me.
well, let's.
I'm in the same, I'm on Francis Ave, I'm right down the street from you, and I'm on concrete piers. So mine is, I think, running into what he's running into on that road.
Well, let's. Do we have more questions at this point for Brad, or shall I allow abutters to speak?
I think we understand what he wants to do. So,
Yeah. Okay. Why don't you take a seat back and let me ask, are there any abutters or other directly interested parties on the Spring Street application for a variance?
It's me.
Yes.
I just come in and see my husband, he's an architect, he built a house, we close to them, and we take the line, what they're supposed to be. When I come in today, there was like point line, metal was like close to my porch, was moved. I know where there was before, so it's like she was incorrect. Another thing, this is very small lot. I don't see the place to,
So I think you're saying that you believe the pin.
There's somebody who will make the measurement, they look like put it there.
What is it, a wooden stick or is it an iron bar?
No, just a red
Orange
ribbon,
tape?
the red ribbon. And I know where there was, because we do it not close to the, I see this is wrong.
So you,
Point metal, the line metal.
It's a
But
different,
then-
But is it a wooden stick or something that's been put there, or has?
No, we put it in a tree.
a little orange thing.
Somebody put
Okay,
a
so-
ribbon in the tree.
Okay.
And I know what this because when we pull this out, know exactly what is there, stick for this. Today was rain, I tried to find out the old ones, but they're supposed to be.
Yeah, the pins in the ground, I think. we're
Yeah,
discussing.
yes, and I know this is very small lot, and I don't know they have, because years ago I wanted to buy the house, because that was close to me, and then they told me they don't have any septic system, that's the reason why I don't get it. So I don't know,
Okay.
and I know this is small,
Do you have any comment about Mr. Billinger's application for a variance, allowing him to put the house up on
I have to talk with my husband, and he said he want to see what he want to do it, because otherwise he say no. You want to see what he want to do it, how he's want to, because, well, that's very close. He a very small lot.
Yeah, so you have are you saying you think he should not be doing this, or you are saying that?
Yeah.
Because
No, it's just they don't have any room over here. I don't know what he want to build in. That's what my husband say. He want to see, he want to know what they, then
okay.
we can decide
Well,
what they want to do.
the drawings of what he wants to do is online, or you can get a copy of them here.
Yes, I can show it to my husband. I can spoke. He's an architect. He designed my house, and he knows what there is to do, like the purpose, So because they really know, I don't know. Your land is very small. It's not. I don't know. I want to know what you want to do with it before we say yes.
Yep, the plans are all clearly laid out for the town.
Okay. Are there other comments? Are we?
You want to close the public hearing and deliberate?
Yes. Well, what I'd like to do is, in at least since there's a possibility we may have more questions, or I'm not quite sure where the discussion is going. I'd like to not close the hearing, but just temporarily suspend it while we deliberate, or at least deliberate during the hearing, and then give us the opportunity to come back. So that's a fuzzy answer, I know, but I'm not closing the hearing. I'm keeping it open, depending on what the outcome of our conversations are.
Excuse me. What was the purpose of the question whether or not his property was on post versus other properties on post?
Is it unique?
Is it unique?
Is it unique?
That's why I asked. People were asking what's unique about the property, and yeah, that's what I was trying to find out.
Well, and that's an interesting argument, or an interesting discussion when we get to hardship, is whether the uniqueness test applies to the property or also applies to the building. And up until very recently, I think most people felt it applied only to the land.
Yes.
But the parade decision in Portsmouth with the sign on the hotel at least raises the question of, is it more than just the land?
Yeah.
Go ahead.
If we really need to think about, it seems to me one of the prime criteria is what is unique about this. If there's nothing unique about it in that area, then we could just stop thinking.
I'm having the same issue. I don't see. I mean, this is a whole group of 15 or 20 quarter-acre
sufficient?
Is that unique?
Is that sufficient?
But
Yeah.
to buy a lot and then come around and say you want to have everything changed because of this, you knew that when you bought it.
Yeah, but
I don't know.
a lot of people know a lot of things when they buy it. But that doesn't mean that they couldn't have
Okay.
a variance.
Now, I mean, if we wanted to proceed, if we, I think the other issue we have is that I think would make it difficult to do anything affirmatively tonight, granting something, is there's still a lot of uncertainty as to exactly where the property boundaries are.
If you look at these drawings, and one scenario is buildable
Yeah.
size
Right.
doesn't require variance at all.
Right.
I think perhaps what we need to do is to get some advice in regard to, if he's got a deed that says, I found the pins, he's got a deed that says it's 116 feet, and it's 100 feet. And, okay, he's got a deed. So what takes precedence here? Does a subdivision plan that was filed take precedence over a deed that somebody sold him this? And I think we need to know that.
You have to look back.
Well, I think the only way honestly, if we...
Or Brad needs to, somebody needs to know.
Well, that's the point. I was going to say that the only way we can truly satisfy that is to have a signed survey by somebody showing where the lot lines are and where the building is. Anything short of that, we're going to eventually have to come back to that.
Well, but Amanuensis is up in the air because I don't think they know the answer to these questions, you know what I'm saying? So somebody needs, it would seem to me that if Brad got an answer or an opinion, I guess it would have to be a legal opinion, as to whether the subdivision plan, which shows a shorter lot, or his deed takes precedence. Because if his deed takes precedence, then it would seem to me that somebody could go in there and survey the thing and do the job and certify that this is what it is. And if his deed takes precedence, then he doesn't even need to be here.
Exactly.
If the subdivision plan takes precedence, then he's got a problem.
When was the subdivision done, do you know? The plan, when was it written?
It'd be, I don't know. I'm not sure.
57.
57.
So, but for us taking action, I think,
Well, if we
I
can't
don't
find
think we're going
something
to grant
unique,
it. Yeah.
then we can't do anything.
Well, does anybody see any way this application can meet the hardship test, fifth prong?
You'd have to think about the size of that lot in relation to the other lots and say, well, this is so tiny, and they're all significantly larger than, that's unique. Then I guess we could discuss
But it's
the rest of it.
.21 versus .37.
Well, there you go.
I'm not certain that any corner lot was
What is
built on that
significant?
subdivision except mine.
Excuse me?
I'm not certain that any corner lot was actually built on other than mine. If my deed does indeed take precedence, there is still a small sliver of the proposal that falls within the setbacks. So we are still, it's not completely covered. There is I did the math earlier, it's like 20 square feet or something that still falls within the setbacks. So we're going to run into the same problem even if I affirm the deed.
Oh, I thought it looked like you had room. Well,
Well, I guess the question is what to do tonight. I'm not sure I see the point in continuing this to next month. I'm not sure I see anything unique here or anything special about this property.
No, I don't think there is, unfortunately.
Compared to the surrounding
Yeah.
properties.
Compared to the surrounding properties.
Except the fact it's a quarter lot.
Nothing.
Well, there's other corner lots there. And if you look at the plan, it's an oval, so there's, at least
Everybody's on a corner.
three.
And even if we get past that, it's still going to be very difficult to get past the hardship test of even if this is imposing hardship on him. He will still be affecting the view and density to some extent, unlike
Not affecting the density, it's
well, yeah, he's expanding.
you're talking about the size.
Yeah, size.
I
It's modest.
Yeah, right.
But we can argue about that. But I do think the where this really fails is the lack of uniqueness. Or I mean, the whole intent is. I mean, the point is the same rules apply to everybody, and the variance gives us a way to deal with somebody who is unfairly burdened for those rules. But your neighbors and the people down the street have the same issues in terms of buildable lot area. I don't see anything that allows you to. Actually, I shouldn't be addressing you. I apologize.
Is it also that where he wants to increase the size of his house is not part of the sides? It's not frontage, it's really his neighbor. It's the 15-foot setback as opposed to the 50-foot setback.
25 feet.
25 foot.
It doesn't follow if he found his deed takes precedence and that affects the position right away, he'd have, I think it looks like he'd have plenty of space. That would just an interesting note on the flood. Everybody's remapping the floodplain, so suddenly we've got things that are supposed to be in flood zones that weren't previously in flood zones. And they have the ability to go down and look at a particular situation, and if it's not high impact, they can actually move the flood line and take this little section out of the flood zone so people don't have to buy flood insurance. And I'm wondering if that wouldn't be a similar situation with this right-of-way, given the fact that his deed, takes a chunk of that right-of-way. Maybe they move the right-of-way over or something. But in any event, that's just that has nothing to do. That's just information, interesting.
Okay, well, let's quickly, to be fair, I think in case there are appeals or anything, we need to at least quickly address everything else.
Okay.
So the first part is contrary to the public interest and spirit of the ordinance. And, I guess the issue is, do you think if we grant this variance, will the essential character of the neighborhood be changed, or would the variance threaten public health, safety, and welfare?
No.
So we think, so that passes. I mean, essentially we're saying this variance would pass the first two prongs.
Seems to be a problem.
Yeah.
So then the third prong
Substantial justice.
would be
Substantial justice.
substantial justice done, and this is again balancing the loss to the individual outweighed by the gain to the general public.
Yeah.
Now here, this is getting a little bit. I mean, I think this is a harder one to come to.
I don't know how to judge that one because putting it in a basement.
But the issue is increasing the setbacks and heights outside the envelope.
It was no higher than the current roof, right?
Yeah, that's
Yes.
In any event.
Yeah.
Well, or we could impose that condition.
You could impose that condition.
We could, yes.
So that really has an impact. What's the other one?
Is what we're talking about is substantial justice. So it's the test between the loss to the individual versus the public benefit.
Gain to the public.
Gain to the public. Addressing things such as view, density, public health.
We did hear from an abutter
Yes.
that there is an issue there.
Okay, well, I think we need to then take a vote here because I don't hear consensus. Who believes that the loss to the individual is outweighed by the gain to the public?
I don't think it's outweighed by the gain to the public. That's my feeling.
Okay, so that would, in other words, the individual is suffering a loss here more than what the public will gain if we deny this.
I think so.
Okay, all in favor of that? I have 1, 2. You're not voting. Okay. There's 1, 2, 3, 4, 5.
No, I believe I heard from a butter, so there is a public concern here about this issue.
Okay, so that's 1.
I would say that he failed that test.
Okay, I think he failed that test, but Dave thinks he passed it.
I do too.
Okay, so
3 to 2.
this passes 3
Well,
to
the reason
3 to 2.
the reason I say that is because even though there's an abutter present, the abutter stated that if her husband could look at the facts of the matter, because he's an architect, he might have a different opinion. But the point is, he isn't here. And consequently, we don't really have a real complaint that's measured on the basis of fact.
Well, it's true. If you look at some of the court cases, they don't have to articulate and defend it.
No,
They just have to say that I am an abutter and I believe this impacts me.
Okay.
Yeah,
So they don't have to delineate 1,000 reasons.
It's already voted.
We
though.
voted on
Yeah.
that pass. The next test is the value of the surrounding properties are not diminished. And it's almost the same issue we have in a butter expressing concern. But even with that concern, I have a hard time seeing how this would diminish the value of the surrounding properties.
I mean, if you put a concrete foundation under a building and it's sitting up on posts, and you're getting, it would seem to me it would improve the value of
Especially if the post rot and it lands on the ground and just rots away on the ground. That would decrease the problem.
So I think there's consensus that this variance passes that problem.
Yeah.
Is that true? Okay, and that was unanimous. Okay, and then we have unnecessary hardship. And the issue here is that, I think we're struggling to find special conditions of this property that distinguish it from other properties in the area.
I just don't see it.
I don't see it.
But how could he build it? So what would the options be?
But he could rebuild, and he has the existing envelope, he could rebuild within that. I mean, he could certainly put it, I mean, he just can't, what we're talking about here are setbacks.
So he can do the foundation as long as he doesn't further encroach.
It's not our problem, but I think he can, based on...
I'm asking.
Okay, so are we unanimous, all 5 of us, that there's no uniqueness here?
Yes.
No special conditions?
No, I don't think.
Okay.
Sad but true.
Yeah. Okay. So based on all of that, I'd like to entertain a motion to deny the variance because we could find no unnecessary hardship.
Right.
Okay.
So moved.
Second.
Second.
All in favor?
Aye.
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 Well, that was unanimous. Okay, so we have denied the variance. I have, within 5 days, or hopefully within 5 days, we will publish a decision that explains why we did what we did. That you have, as you actually heard earlier today, some kind of outrageous, an extreme case of denying things that were not intended when the zoning ordinance was passed. Does that make sense?
It does.
Okay. So I also then close the hearing on Bollinger, and we'll turn to the last public hearing, which is Mr. Terry, and that is on, let's see, what property is this? That's Francis Ave, 32 Francis Ave. Have a seat. And again, we have provided notice, and Everybody returned their green card except one abutter, Devovier of Swampscott. So at least you've heard the drill.
Yeah, I'm just trying to, how I can present this in a way that I can ask the board for you guys to provide a variance so I can move forward. But I tried the best I can. I'm new at this, so I'll do the best I can to answer the questions as you guys
Well, in this case,
fire away at it.
my understanding is there's a small corner of your property that
I can,
yeah.
It's in the existing conditions diagram.
Yes.
Yeah. See, when you guys I was listening to you guys earlier about how you're giving so much information. Obviously, when I purchased a property, I had no idea that this cabin fell within the setbacks. This all came about when I hired a gentleman to do the septic design because it's a failed 55-gallon drum type scenario up there. And in doing that for the septic system, which also got denied until I hired the survey, and I did cover all that you guys are just discussing. The property was surveyed properly, and I fell within everything. The setback lines showed up just as I was about to get the building permit, and we all sat at the round table and just realized that the setback line, the cabin is to scale, is about 5 feet of the corner of the cabin falls within that pin that's up at the top. Did anybody go to the property?
I did.
I drive up.
So when you stand at the top of the driveway, there is a pin right there at where that wood shed is. So you're looking down at the cabin. So they measured in, it's 50 feet into the corner. And it goes about 5 feet into that corner where the meter socket is. So that's when I got denied the building permit, and that's why I'm here tonight after applying for variance to do the addition.
I had a question here.
Yes.
There's currently a deck on the front of the house. In the current plan, it says a little deck on the cabin in the front.
Yeah, it's
And in your renditions for your new addition, that doesn't appear to be there. Are you taking that off?
no. That's actually now. There's a. I don't know if you can really see that. That's what it looks like.
That's the cabin, and the deck is
That's this little thing.
little thing that's through the trees.
Okay.
Right.
This is the side right there that I was looking to go up.
It's the cabin itself is well below grade. I actually have a photo. You can see. I know you guys are concerned in respect to the ordinances in Jackson about the height of the buildings and blocking.
Well, you don't block any views there.
Yeah, that's. I didn't know if that was a huge factor, but I mean that's.
But you are in a flood zone, the federally marked flood zone. I was wondering.
Floodplain or the floodway? Yeah. There was one difference. I was in the lesser of the two. That's standing from the street on the dirt road at Francis Ave. You can see that the cabin is significantly below grade.
Well, we have the same, I don't know if it's a problem, but we will have the same question that we had from Brad, and that's what's unique about this property situation in relation to other properties.
Well, I was asked a couple questions when I sat down with the building inspector, well, why don't you just do this or that? The fact that it is pure concrete blocks, the hardship for me is that, I had no idea the setback was in the middle of the, taking out the corner of the cabin. I'm not changing the footprint out. Is the design of the cabin to put the staircase. He goes, well, why don't we just put it on the other side of the cabin? But there's 10 windows and a wood-burning stove on a block and brick hearth in the living room. I have no place to put a staircase to go up to the second floor. And that's why, majority of the reason was the layout. I couldn't really do it any other way.
Yeah, that's...
If you do a Your site plan that was sent back from DEP said that you need site plan review if you build anything down there. You familiar? It's on a
Because of the
flood.
flood?
Because of the floodplain. And just one
So
other.
DES needs to know that?
DES needs to know if you dig it down there, I understand. And also your septic system.
Oh, yeah, the septic, by the way, this came in Wednesday. You guys don't have this. Oh, no, this, yes, ma'am. This just came in Wednesday.
I can understand.
This is it did get, Burr finally sent it out, but I had to have a survey. Ron Briggs from Conway came in. Between the line at the top of the driveway, top of the driveway. To the left of the top of the driveway, there was a question where the property line was, and that could have changed where the septic system was going to go. But this is the stamp approved that you guys do not have. This just came in Wednesday from the state of New Hampshire.
But again, well,
No, it's just to bring it to everyone's attention, there was a note written on it somewhere over there about site disturbance, just in terms of.
Reference to the septic.
And also, the other piece that's attached to it says that waiver granted. This approval is granted only to improve the existing situation. Please be advised that if construction of this lot involves dredging or filling, I think that's the standard. The other piece here. That my impression is that the septic is granted to improve the existing situation. The septic is not for a new building. That was my impression of how this is read. Can someone explain that to me?
Well, if he's not adding bedrooms, kitchen.
It can only be for a two-bedroom. That was made clear to me that it could only be for a two-bedroom.
We may have to improve the system.
Why I started this whole process is inside the cabin. I'm really just trying to improve the living conditions.
I thought that the cabin, I'm sorry, I thought the cabin was just one bedroom right now. The two?
Well, it's got two little 7x7 rooms, and the toilet's in a closet. So that's why I started this whole thing. That I just want to make a second bedroom on.
well,
But,
unfortunately, I'm in the same situation I was.
We're in the same unique situation.
I mean, this is.
So maybe what we could do is we don't have an awful lot of information about the surrounding properties here now. Although I know some of them are in the same situation, it's kind of a mess. So that's what we're doing. But maybe we could continue it to another meeting and have an opportunity to get more information about the properties, other properties in that area, so that we could see better if there is something unique about this property. Frankly, I don't think we're going to find anything, but we could.
Ultimately, it's up to the applicant to prove that to us, rather than for us going out and trying to find it.
The problem, I was thinking about this today, and this is kind of hard, but point I might think about this. We get applications, which, with the exception of something that's handled by something like Cooper Cardinal or Chant, whatever they call themselves now, people don't really understand, what they're trying to explain to us. So we get these things, and they don't address the things that we feel need to be addressed.
Well,
because they don't get it. They don't understand the uniqueness of the property or what hardship and so forth. There must be a better way.
Well, I mean, you're not aware of it, but we do have responsibility to, and I as chairman have responsibility to help people in their applications. Everybody, Brad and is it John? Yes, John both got basically the same email that points out the criteria that we use, refers them to this book and certain pages in this book, and explains how we make the decision and what those criteria are.
Yeah, I suppose.
So, I mean, what we can do if John asks it is to continue this and allow him to amend his application if he feels he can, if there's an opportunity to show.
Isn't this a hardship in itself where the ordinances came in after the building was built? That's something that was out of my control, but isn't that a hardship having a building in the setback already? I'm not building the building in the setback.
The issue, I just remembered that before we get into deliberation, we need to see if there's anybody else who has anything to say, any of others. There are.
I'm on the bottom of a property owner on Moon Road, and I kind of ran into that same situation when I did my camp. And is that property down there non-conforming property? The building?
The building is down.
It's not conforming in that a portion of the building are in the setback already.
Okay.
So, that's grandfathered. There's no harm there.
Yeah.
The issue here is Mr. Terry is seeking to enlarge the building in the setback.
That's what I tried to do too, and I got denied.
Yeah. And again, that comes back to the argument that we've been discussing is, unless there's something special, especially unique about your property,
in relation to the other properties around, in your area.
We have to.
They all fall under that. They're all 2 feet from the roadway.
My property.
So what am I supposed to do?
Well, the town has denied permits in the past for expansion of this property. Yeah, well, that's what's his. That's what happens. They can't expand.
Mine happened to be 4 feet above the 100-year floodplain, so I was able to improve the existing building.
Let's be careful we don't get into a three-way discussion here. I think we've heard your statement.
Frank, can I ask a question? Going to be digging basements or changing pilings. Why don't you just take the house up and move it to where it's supposed to go?
Well,
Isn't that a choice they have?
A checkbook.
yeah.
Oh, okay, all right.
It's part of the problem with the construction, and this is why I was looking for the
But they're already digging.
variance. I can't build over 10 windows. I can't do it.
First could afford to do it.
Oh, I don't know.
The hardship issue is the uniqueness deals with what's unique about the property, especially the land parcel and not the existing building. And to the extent that you're being treated the same as everybody else on Francis Ave and Spring Street and Maloon Road, and everybody has the same issues, it's very difficult to grant a variance.
Well, what makes it unique? What do you have to have something to make it unique? I don't understand. There's a ton of things that make that thing unique.
Well, then,
I bought the thing if I knew setbacks were there. I had no idea.
I understand. I'm willing, if you wish, we are having a meeting next month. I was glad to, May 15th, May 19th, is it? June 19th. I don't mind continuing it if you think there is something, if you want to try to amend the application. I'm not, I shouldn't offer my opinion about your likely ability to do that, though.
What am I going to tell you? That's why I'm here tonight in person. I go up here so I can show you what's going on, tell you what's going on. What am I going to change? It's, the layout inside. I can't put staircases in various locations. I can't build out on a footprint in certain directions.
That's true.
I'm already in the setback. What am I supposed to do?
You can build to the south, I think. Isn't that right?
No, it all slopes down. There's trees all over the place, and it's on pier construction. There's no foundation. What am I supposed to do?
Well,
As it stands,
there
without the...
are properties in town that people purchase, and they come and they want to make changes and they can't. So the answer might be that, well, you can't make those changes, or you can't make the changes you'd like to make. Maybe you can make some other changes. That might be the answer. We're just saying that if you can figure out what's unique about your property in relation to the other properties there, it might be the lay of the land. It might be a tremendous amount of lead. You can't move the building or something of that sort. That would be the kind of...
The biggest thing is the wetlands. That is a huge, and they're marked out if anybody's gone to the property, the blue
I
tags.
didn't go down on your property. I didn't.
I'm surrounded by wetlands, and I can't move the building in any direction.
You're the only person up there that's got a wetland consideration.
And that's a hardship, isn't it?
I don't know.
No, but
I'm
unique.
asking you.
I mean, it's
Would be
unique.
unique.
To me, it is.
Well,
How am I going to move it?
then that might be what you...
That might be the answer. Is it? Could it be? Could that be the answer?
I don't know. I don't know what the
You would
situation
have to
is.
have evidence to show
Exactly.
that would be what.
That's you aside for everybody
If
else.
your property were the only one in the area that had that problem with wetlands and no other buildable space, and that would be a presentation you would make, and say, I need this because I have wetlands, I can't do anything.
How do I tell you that? I'm telling you that now, because I know the flags are
You
there.
have to
do the research.
Show evidence of that. You have to show other properties, your properties, where the wetlands are in relation to the zoning law. That's what you have to do.
Would you like to come back in a month? Or should we?
4.5 months now, so what's another month? I guess I'll have to. I don't have a
Who's going to
choice.
do the work on it? I'm just curious. You gonna do
Yeah,
some?
myself and a carpenter, yeah.
Okay. Since we're going to continue it, we don't need to make a decision tonight then.
No. Before we make a
will have
decision on whether to
we'll
continue.
have to make it, we have to, do I have a motion?
I make a motion to continue it till the
Okay.
June 19th.
of June.
Second.
Okay, so I'll explain in a second. All in favor?
Aye.
Okay. So we're going to continue this hearing to receive new evidence at our next meeting on June 19th. So there won't be a additional certified mail going out. There will be a public meeting notice posted, but that's all. Any abutters who, John will have an opportunity to present additional information, and abutters will also have a chance to react to that information. And yes, I'll answer your question.
I have a question. When properties like that are up for sale, why isn't there a disclosure? So guys like John here, when he is looking to buy a piece of property situated like that he knows that it's a non-conforming building or it's the setbacks aren't, why does it?
I was actually told by 2 town representatives before I even purchased the property.
And the reason why I asked that is because there's a property across the river from mine that was sold, I don't know, I'm going to say about 10 years ago. And the guy tore the building down. And then he went to build something else, and then all of a sudden he just got shut down. He already put an artesian well in.
Okay.
He already had footings
Those are
in.
all,
Well, I mean, a couple things. One, to answer, you're raising an issue of, actually it's a estoppel, that the town has already told you could do something. That would be an argument that you should present in a month. In addition to the questions on uniqueness. But to answer your question, when properties, certainly there are surveys done when you get a mortgage, and the bank is interested in whether or not you're violating zoning. So it is something that is done. Why some people don't do it, I can't answer.
It
But
would be a question of ethics, I would think, for the realtor and the person that's selling the property.
Yeah,
I don't know what realtors are obligated.
That's where the Latin term caveat emptor comes from.
But when I ran into this problem, all I ended up doing is just fixing up the camp for what it is.
Yeah.
And that's all I could do, and that's what I did.
Easier said than done. So where do I get this evidence on everybody else in the community that has wetlands? How do I find out this information?
You are in your area, your neighborhood.
Your general area.
Francis, they have those streets up there.
Where do I get that?
well,
Who do I call? Where do I find
I
this?
mean, we can help you up to a point, but I can't, serve as your counsel or.
I understand that. I get that.
I can point you again to there's a number of cases there are a number of legal decisions that talk about this hardship issue, and the uniqueness, and I'll be glad to send you an email with citing some of them. You can look at them and see if it sparks any ideas. I mean, I'll tell you, my right now, I don't see, right now, I have a difficult time seeing how you're going to make that case. But maybe the wetlands is an area that we can find a way to do something.
So what happens in a month when I come back? If you see that being a problem now, I come back in a month.
Well, if you come
What's
back
gonna
with,
decide that?
information that shows that it is unique because of that, then that would be a different situation.
Within that area.
And the other thing is, Frank mentioned estoppel. If town officials gave you assurances of something, then you should bring that information forward. Who they were.
Town officials
or what they said.
I'm not going to name drop and say something else. I mean, when you
you'll sink it.
this is all prior to knowing where the setback was. There was nobody told me. I didn't know this until it was surveyed.
Yeah.
Who's going to know that? I mean, who would have known this? You know what I mean? What buyer goes into a home and surveys the property before they buy it? Who does it?
In New Hampshire, it's a very smart move. It's a very smart move in New Hampshire. It's a pain in the neck, but it's a smart move.
Okay, so
otherwise,
I've officially continued the hearing to June 19th. So the public hearing is finished, and that's the last thing on our agenda for tonight. Before I entertain a motion to close, are there any other comments?
Yeah, for years now, this tax thing has come up. The taxing a whole bunch of lots that are not buildable under today's standards, and yet that is always the argument comes up, and they always get to build. No one's ever, gone in and said, we're going to change the policy around here. So I'm just making it.
If it's a law of record, you've got a right to use that law. It doesn't have to meet current standards because it's a law of record. Now, it's got to meet some current standards of septic and so forth, but because it doesn't have 200 feet or it doesn't have that, it's still a law of record.
You're referring to the Evans case. The 67441 just gives us a mechanism to make the access adequate.
Right.
So it doesn't take away his use. I mean, ultimately, that's where we should end up.
right.
But
No,
so,
it's not for us, but it keeps coming up. I've heard it very, so often in many different things.
it's still
They're
appropriate.
saying he's saying that's a stop. You keep billing the guy, telling him it's a building lot, charging him for a building lot, then you can't come back and say it's not a building lot. Well, that's an argument to be made. Just as this guy said, well, I was told by town officials that everything would. Well, if you were, we had a case up on Francis Ave where they had gone ahead and built. They were within setbacks. I mean, it was really a mess. But they pointed out that certain town officials had told them everything was fine. Don't worry about it. You don't have to do this. You don't have to do that. And the building inspector had been there and looked at it and said, yep, that's just nasty. Well, then. There you go.
Okay, on the Evans case, can Cargill raised some issues that I wonder whether or not I should consult with an attorney on his arguments, or do we think they're so?
No, I think you should.
Okay.
He made in that memorandum that
Yes.
he made some good arguments, and then now you've got to have an opinion as to whether he's right or he's wrong. I think your reading of 67441 was accurate. He doesn't think it's accurate. It'd be nice to have.
Well, you look at it from a different perspective.
His clients.
Okay, well, I will.
The bills.
Just to make the whole board aware, I actually on that, as well as the motion for a rehearing by the selectmen, I thought there were some fairly good legal issues raised. I attempted to have a discussion, including Joan as vice chairman, with Peter Malia, but there's a great deal of email back and forth, including all three of the current selectmen, and especially since in the case of the rehearing request, there was at least the possibility that the selectmen could, if the motion were denied, take it to court. That Malia would, there'd be obviously a conflict of interest. So in the end, I never did have a conversation with Peter, and Peter's suggestion, of course, was you should find another attorney. So I think in having the discussion on Evans, I will see if there's another municipal attorney to talk to.
It's always a good idea to start with the LGC.
I will.
Yeah, and because that they may say, oh no, absolutely, you're absolutely right. But they won't put you right.
They don't.
They won't tell you.
They don't.
Well, sometimes they do.
I think in the case of Evans, it's given. I think it's if we are unable to reach an accommodation, unable to find a way to grant a exception, it's more likely that ends up in a court. So I would feel comfortable at least starting off with somebody beyond the LGC.
But they could come back asking for an exception, and
He just wants to be prepared.
yeah, and that might make a difference because you can make an exception to 6
With conditions.
Yes.
With conditions.
I mean, I think in this case, well, I know I'm prejudging it a little bit, but a big issue would be the width of the bridge and emergency vehicle access and so forth.
Well,
and
30 foot.
That's good to know.
Right away.
30-foot bridge?
12-foot driveway.
Well, that's a sharp turn in from Black Mountain Road too. I mean, just imagine the fire truck trying to make that turn in the wintertime. But that will be next month's discussion. I was hopeful that we'd finish by 9, and indeed we were able to accomplish that.
Considering the motion to adjourn.
Yeah, one other thing. There was a building permit denied on the Wentworth, and I anticipate that there'll be a variance request for
I
that.
saw that. What's on the? Is that just the denial letter that's on the website now?
There's actually, I haven't
look
seen.
at it,
There's nothing there. It's an empty folder. I know because I know it's coming. At least Andy Charles suggests that it's certain that Fritz is going to apply for a variance. It has to do with the height on a. They want to take down increase the height of that building that's just directly, upriver of.
Oh yeah.
Yeah, it's kind of falling down a little bit.
Yeah.
And I believe they want to make it about the same height as the existing main building.
Oh, good.
Fritz doesn't like to come to the ZBA.
Well, it's the only way it's going to happen.
Yeah.
So I think what I'm trying to say is I think our meeting in June We'll deal with Evans. We'll certainly have another discussion with John Terry, and then I anticipate that we'll have a variance request from Fritz as well. And the denial letter just went out, I think, last week. So, motion?
Would you entertain a question from the board?
Yes.
I have trouble understanding how your decision will go under comports with your decision on Rupert.
I think the
area.
With respect to hardship.
The hardship, the test on hardship include looking, comparing, balancing the purpose of in this case, the setback requirements, which we, as you may have, as Dave mentioned, included aspects of things like view, density, and so forth, with the specific application of that setback requirement in what Rupel wanted to do. He's building.
Well, and also important, which Oringer didn't have, is the uniqueness of that property in relation to all the other properties up there. And it is unique. And it's the only property up there that has a 50-foot setback on one street and a 50-foot setback on the other street.
I think somebody gave a number of something like 60% of its lot.
So that's unique.
Fell within setback.
In that area. In that area.
So
in that area.
In that area.
So it has the element.
This was not unique in that area.
In that area.
So it has the element. This hardship test has a couple of pieces to it. One is there has to be special conditions or uniqueness in that property that distinguish it from others in the neighborhood. The second part of it, though, is that you have to look at the purpose of the setback and how and the benefit the public will gain in the specific application of the setback in that case versus the loss to the property owner. We felt on North Hampshire Ridge, in that area, the principal purposes of setback and height, for that matter, were protection of view, maintaining a very low density environment, and so I'm sorry, rural character. And because Rupel is building the garage into the hillside up against North Hampshire Ridge, and the ridge line of the garage is actually expected to be at or slightly below the traveled way of North Hampshire Ridge. We could not see how the view would be impacted, and in fact, if Rupel built the view impacted for the neighbors, and in fact, if Rupel built the garage elsewhere on his property, which would be, probably have to be built up and everything, there'd actually be a greater impact to the view of the neighbors. That was certainly a big element of why we felt we could grant it. I think we were also certainly influenced by all of his neighbors. There were at least 4, if not 5, abutters here, all speaking strongly in favor of granting it. Plus, I got one letter of somebody who didn't attend. So, so that was really the value of surrounding properties and so forth. But that also led a little bit to trying to find reasons in terms of the purpose of the setback and its application in that unique property. It was not an easy decision for the board to make. It took 2 meetings, and that's all we talked about for 2 meetings, how to do it. And we ended.
The minutes of the first meeting regarding it seemed to be 180 degrees out of your second meeting.
I think that sometimes you'll hear a whole roll of one side and then a roll to the other side. As we explore, one of our responsibilities is to explore all avenues, whether they're, I was talking about things today that
So with something irrelevant tonight, they're going to be very relevant in the next meeting, the next hearing. It seems tangential until we get all the issues done, because it's really our responsibility to do that.
Thank you for suffering my questions.
No, it's glad to answer them, actually. I mean, it was a case that was very closely balanced, and we had great difficulty kind of trying to decide what the right answer was. And actually, as I mentioned, I did my conversation with the LGC, with Christina at the LGC today, that dealt with exactly that issue. She elected not to make an opinion or offer a statement, and felt that she could see our argument and thought it was reasonable and could make that, and she could also come up with other arguments why it shouldn't be. It was I don't know what to say. It was a hard decision to make.
We have not adjourned yet.
Well, the uniqueness is the biggest difference.
Yeah. Okay, all in favor of adjourning? Aye.